is our Keller-Williams purchase agreement explained. An explanation so you can understand what each paragraph entails and how to explain it to your clients, along with how to fill in the proper information. So, on our offer to purchase, our section 1 is going to let you know where that property is located. So if it's in the city, township, or village, you're going to fill in an example such as like Canton. Canton is not a city, Canton is a township. In the county of Wayne, you'll fill in the correct tax ID or property identification number that can be found on the MLS or by doing a property records search in RealComp. Same with the legal description. You're going to copy and paste that entire legal description into this section right here. Commonly known as is 123 Main Street, Canton, Michigan, 48188. That is an example of the commonly known as address. That's going to be what you're going to fill in there. From here, this is letting you know that's anything that's built into the house. If there's anything that's not listed here, specifically include it on an addendum. So for here, it's anything that's screwed into the wall, anything that's not chattel. So go through that list. If there's anything that's being excluded, make sure you have that on an addendum as well. You want to be as specific as possible here. The sum of this first line here, you're going to put 123,000. You're going to put the numeric number of the purchase price. Down in the second line, you're going to spell it out. You're going to put it out in all complete terms, 123,000. You're going to fill it out. Okay. For the second section of this first bullet point is going to be how they are going to consummate the sale. So how are they going to complete the sale? If it's cash, it's super easy. It's just that first checkbox. Most commonly in our business, that's going to be B. It's going to be a cash sale with a new mortgage, which means that the buyer is going to have to get a mortgage within a certain amount of time, that it's going to be the delivery of the warranty deed and marketable title, which means the seller can actually sell the house, and it's going to be a warranty deed, which is the most amount of coverage on a deed as opposed to a quitclaim deed. Other financing would be something such as a land contract. We don't see that super often. So for our cash sale with new mortgage, you're going to select that B option. You're going to go ahead and put VA, FHA, conventional, whatever that case may be. In the amount of, again, it's going to be dependent on what type of loan you're doing. If it's going to be a VA mortgage, you're going to have to do the amount, say that's going to be the entire sales price of the property, and they're actually going to pay 0% down. If it's an FHA, they're actually going to do 3.5% down, and they're going to pay 96.5% on their mortgage. Now if we're doing a conventional, this can range. The amount can be 95%. The amount can be 90%. Again, most commonly it's going to be that 80% is going to be the financed amount and 20% down. This all depends on your lender and how that mortgage needs to be written. This number is always going to be about 45 days. That's how long it's going to take for that buyer to get that mortgage. My apologies, this section is for 7 days. This one is 45. My apologies on that. 7 days is how long after all of these other conditions such as the private inspection are satisfied that they are going to apply for that mortgage, that they're actually going to send in the application, is how many days after. Again, most commonly is 7. Now that commitment needs to be issued within 45 days of that application. That means that everything needs to be a clear close and ready to go in 45 days. Again, this is just a guideline. Most people do not enforce it thoroughly, but you definitely want to put 45. If you have a loan or something that's uncomfortable, talk with your lender, see if they need to put 60. But again, most commonly, this is the type of information you're going to see, is that 80% conventional loan, 7 days, and 45 days. Okay, so that second section is just what type of financing they're going to have. The occupancy section is actually on page 1 and 2. So it's going to be the following tenants. If there's any tenants, then you're going to want to put that information in there. If it's the seller, you can type seller, or you can just leave it to where that second sentence overrules that tenant name. So how many days have you agreed upon on or before closing? Have you agreed 30? Have you agreed 15 days after closing? Have you agreed 60? It's just whatever that offer is going to include. How many days after closing? Okay? After closing is how much are they going to pay a day. Something you see a lot is new monthly mortgage payment plus taxes and insurance. So that's that NMPTI. It would be 1/30th. So this means it's going to be 1/30th of that new monthly mortgage payment, taxes, and insurance. There's a couple other deviations of this, and PITI is another one you'll see. It's just whatever one that you need to use. I was taught the NMPTI way. It's just going to be whichever one you're more comfortable with. This means that they're going to pay 1/30th of that payment per day. So if they're paying 30 days, they're in essence going to be making one full payment because it would be 30 of 30. They're doing 15 days, it would be 15 of 30, so they're going to pay 15/30ths. Okay, so that's how that math will work out. For this, you're going to want to put 1.5 NMPTI for that security deposit. You're going to want to hold 1.5 times whatever the amount is that they're holding for closing. If they're closing 30 days, then in essence you're going to want to be holding 45 days. That's where that 1.5 times comes in. It's 1.5 times the new monthly mortgage payment, taxes, and insurance. So if my new payment is $1,000 a month, then they're going to be holding $1,500. And if you wanted to see how that math works out for that right here for the daily rate, you're going to do 1,000 divided by 30, which gives you about 33, 34 per day. That's how you figure that math out right there. It's always good to leave this as just at that 1/30th and not put in an actual amount. That way that amount can be turned upon once everything is written on the closing documents. The second section of this is if the sellers have tenants in the property. Again, it doesn't happen super often. Is if that B option is selected, it means the purchaser will assume being a landlord. If it's A, it means the seller will have the tenants vacate prior to closing, just as it is written. That third section is going to be how that deposit is going to be taken. So again, talk over with your buyer, see what it's going to take for that EMD, that earnest money deposit. That amount is going to be put here. It can be $3,000, it can be $10,000. Just depends on your circumstances of the offer. And of what means are they going to do it. Don't take cash and don't take a promissory note. You're going to want to get a cashier's check, certified check, or personal check. You'll select which option you're going to get with that amount, and that is going to be written out to Keller Williams Realty. It's not made out to you as an agent. It's made out to Keller Williams. You'll see when we do our additional conditions another recommendation we have on this. But for here, it's going to be the amount and how it's going to be taken. Don't sign here if you have not collected that EMD. This is acknowledging that you have received it. Okay, the closing date is number 4. The closing is going to occur on or before whatever date you need. Again, it's usually about 45 days out. Can vary depending on the circumstances. Talk with your lender. Number 5 is that additional offers. That means that other agent is not responsible to submit any other offers to that seller once your offer has been accepted. Number 6 is your seller's disclosure statement. It means you have or you have not received a copy of that statement. You always want to include that with your offer. And if you have not, you always want to add in your additional conditions that it's subject to review of the seller's disclosure statement by your buyers. Number 7 is your notice of agency relationship. This is another form that you'll fill out with your buyer. It is disclosure regarding agency relationships that lets them know that you are indeed a buyer's agent and we're looking out for their best interests. Additional documents. This is if you need to include anything such as an occupancy addendum. If it's an FHA offer, you'll need that FHA addendum. Same with a VA. If there's an HOA addendum, well and septic, this is where you'll just select if there is one. You don't need to go into detail on the terms of that, just if there was something else included. Your title commitment. This section is letting them know that they need to issue clear title to us at the time of closing, and that if anything comes up, that they will have this amount of days, they'll have the 30 days to let them know and let us know if they're going to be fixing it, or we can choose to not move forward with the sale. But this is just letting us know that they are going to have all those exceptions cleared and all of those contingencies cleared on the title commitment. This is going to let them know that we are electing to use our own title company for our lender's policy. We actually use Title Solutions. So we'll select Title Solutions, and yes, if there's a reason you're using somebody else other than Title Solutions, let us know. We have a really good working relationship with them, and we need to know why we're not going to be using them. If it's a cash deal, then you'll be using the seller's title company, as there will be no lender's policy. Number 12 is default. This means that if for whatever reason the buyer defaults, then the seller is able to go after that earnest money deposit. So that means walking away for absolutely no reason. It does not mean that the seller will get your EMD if you have failed to obtain a mortgage or if it fails during private inspection. You'll still be able to keep your EMD in those cases. Taxes and assessments. Again, this is going to be something that the title company is going to figure out. This will let them know if the taxes are going to be prorated or in arrears. It all depends on the county. The most common is they're paid in advance, which is super easy. It'll be all based on the date of closing. Everything will be prorated on that 365-day basis. HOA fees are also covered in here. For the water escrow is $200 that the title company is going to take out just to make sure that final water bill does get paid at closing. Our affiliated section is just letting you know that we are able to do anything that's within the law, and we're able to take those fees, and just letting you know that we are affiliated and have the ability to do so as long as it is covered within our realm of not violating RESPA. This as-is section is letting you know that we are accepting that property in an as-is condition, that we are still able to have that property inspected, but it will be an as-is. That means if a tree falls on it prior to closing, we're not buying it with a tree falling on it. The seller will need to fix that because it is not at the time that we inspected the property that it was in that condition. It also lets you know that that seller needs to have that premises broom clean at closing. A walkthrough. We have 48 hours to do a walkthrough prior to our closing and or after our occupancy. And again, at this time, it will be in that same as-is condition. If there's something that is not in that as-is, means that we need to have it addressed, with the exception of normal wear and tear. Financing. As it says, it is understood between the buyer and the seller that in the event of a balloon payment or any methods of financing, that the buyer is going to be responsible for that, and so is the broker. The broker is going to be held harmless for anything having to do with the buyer's mortgage. It means the buyer is responsible for the buyer's mortgage. Time is of the essence. This means that we are all moving forward based on the timeline set forth in this agreement, unless anything has been written in an addendum or specifically agreed to in writing. In writing. It's a legal document. Anything in writing. This is a legal binding document. All purchaser and sellers acknowledge they have been advised to consult an attorney. So we fully recommend that you can go ahead and hire anybody you want to review the contract. It is at their duty to do so or not to do so. This number 20, this agreement, again, relates. It needs to be in writing. There are no verbal agreements in this. It needs to be in writing. For here, our contract language. If 2 or more persons execute this document, then everyone responsible for them is going to be liable to have this go through. It means their daughters, their sons, if somebody's deceased, it means that you should still move forward with that contract. It's still binding. It's also letting you know if there's any words as he or she or they, it will need to be pronounced gender neutral, and if it's singular or plural, that it'll need to be respectively depending on how it applies in that particular bullet point. For here we have our disclaimer section. It lets you know that the broker is not responsible for any promises, guarantees, or warranties for the property. That means do your due diligence. Our private inspection. You do or you do not want to have a private inspection. Again, depending on the circumstances, if it's a highest and best situation, check with your private inspector. Maybe you can get in there in 3 days. Maybe you can get in there in 5 days. Maybe you can get in there in 7. The next section is going to be how many days after you have that inspection are you going to get back with the seller. 2 days after the inspection at the latest is when you should be able to get back with that seller and let them know how you want to move forward, or if there's any errors that you need to have them fixed. The following section is how long do you want that seller to take to get back to you to find out if they're going to obtain quotes, to where if they're going to get it fixed, or if they're just going to tell you that you need to take it as is. If you don't get back to them within these timelines, that means the seller is assuming that you are moving forward and you did not do your duty to maintain those timelines. The last little paragraph is also very important. This is what lets that seller know that they need to provide a certificate of occupancy, if applicable, in that city. If you don't know, check with your administrative staffs. Call the city. Will find out if it requires one. Some are different. Some if it's just a new construction. Others are a lot more strict and they require not only a certificate of occupancy inspection, but a furnace inspection. If your buyer is actually going to assume any of these responsibilities, it needs to be on addendum, clearly written, or this entire paragraph needs to be stricken. During this private inspection time, this another little bullet point to watch out for us is to make sure that they are doing all of their due diligence on schools and ordinances, easements, restrictions, and all of the other information that has been provided to make sure they are buying the property they think they're buying. 24 is our flood insurance clause. That means if flood insurance is required after 72 hours of notification, they can deliver that null and void. So if the seller accepts the offer and then the next day says, hey, this property actually requires flood insurance, we're in a flood zone, that buyer has 72 hours to turn around and say, you know what, we're actually not going to move forward because it's an added expense that we did not realize. Arbitration. So again, this is going to be a clause that your buyers are going to have to do or do not wish to do. Arbitration is a legally binding thing that you will do with a court system. There's mediation, there's a judge, and there's arbitration. Arbitration means that this cannot be overturned. A judge, you can go back and appeal. Mediation is where you're just discussing terms and maybe you can agree. But the arbitration is going to be a legally binding ruling. So this is very important. If they're not comfortable, they could get a worse deal, they could get a better deal. So it's just going to be on whether or not they want to go to court or arbitration. Transaction fee. Our standard transaction fee is $450. This transaction fee is actually, as you can see, is paid to our brokerage. This is for, excuse me, this is for our record keeping, our 7 years. If for whatever reason anybody needs these documents, we will be able to do so. We'll be able to provide them with what they need, along with making sure that everything gets recorded properly. If somebody says something about this, then you need to check with your broker to find out if you can even reduce this fee. You may be able to reduce it to something like $400 or $350, but check with your broker before doing so. And electronic signatures, just letting you know that if you see anything on this, that it is legally binding. Principal residence. This is letting you know that the property is homesteaded. If we know at the time of the offer that it is not homesteaded, the seller is not responsible for getting it homesteaded. However, if the seller does remove the homestead status prior to closing, then the seller is going to be responsible for paying that difference. Foreign Investment Act lets them know if it exceeds that $300,000, then they are going to be bound to those requirements. Again, it's something we rarely see for our foreign investors. Number 30 is MLS items are going to become part of the purchase agreement unless otherwise excluded. As I mentioned in clause number 1, we want to make sure we are as specific as possible. If you see that bar fridge listed on the MLS but not on your purchase agreement, chances are it's not going to be included. So you just need to triple check what you are doing. Same as if you are on the listing side of this, if somebody includes a dishwasher and there is no dishwasher in the house, then you need to make sure that's removed, or your seller is going to be responsible for including that dishwasher. Your agency. This goes back to your disclosure regarding agency relationships. You're going to want to put who that listing agent is and that they are the sellers exclusively. What is your name? Who is the selling agent? And that you are the purchaser exclusively. Our next section is going to be that home protection plan through America's Preferred Home Warranty. Again, depending on if you're asking or declining for America's Preferred. If you're going to accept one, and if the seller is going to be paying for it or you are going to be paying for it, at how much? They start off at $425. If you're in a highest and best situation, again, maybe think about excluding it. If you're in a rundown home prior to your private inspection, go ahead and add that on there and see if you can get it accepted. Good negotiating tool. Expiration is something that you can work on including as well with your offer. It will expire based on what date and time. Let the seller have a realistic expectation of when you're looking to hear by. Counteroffer. If the seller is going to make a counteroffer, let them know when it's going to be remained valid until. Just like your expiration of offer, they can also have an expiration of offer. For that last number, 35, is that appraisal section. Lets them know that that house must appraise, or else this will be voidable by the purchaser, and the purchaser will be able to keep their EMD since it did not appraise. Something that we always want to include in our additional conditions So you're always going to want to have that earnest monies deposit to be tendered within 48 hours of satisfactory private inspection. If you don't include this, that EMD needs to be turned in within 48 hours of seller acceptance. Another helpful hint is all appliances and list those out. You're going to want to put as many of those as possible to make sure that they are leaving. Now, if you have something such as a playscape, do not put it here. Pool table, anything like that, that is chattel. It doesn't belong on your purchase agreement. Put that on an addendum. Okay? So those are just some of the helpful things that you'll want in those additional conditions. From there, this is where your buyer will sign, saying that here is my offer. you have two buyers, then they'll both sign in either signature line. This is letting you know that you want 3% of that sales price as your commission. And this is where the seller will accept the offer. Once the seller has signed this, you will need to bottom line here with your purchasers. If there are any changes made to any clauses up in this purchase agreement, you will need to put initials next to those as well, letting everybody know that every single party involved in the transaction is aware of every single clause on this contract, including any changes that have been made later on. So that's just a quick overview of our purchase agreement as it sits today and a quick explanation of each clause. If you have any further questions, let us know so we can make sure we get those answered. Or if anything wasn't clear, please let us know so we can make sure that we have further clarification and are able to explain this to our clients in the best way possible.